What I'm going to allow is a portion of the videotape of the one officer from the time he approaches the car until Mr. Floyd is out of the car and handcuffed. And I apologize, I don't have a timestamp, but it's very clear that there's a shot of the back of his shirt. He's wearing a black shirt. At that point, he's been handcuffed. That's all that would be admissible. The pills that are in the crack of the seat would also, there's a photograph of that, that would be admissible also as part of that scenario. And then the blood pressure and Mr. Floyd's statements regarding, that were made for purpose of that medical diagnosis. The whole point here is we have medical evidence on what happens when Mr. Floyd is faced with virtually the same situation. Confrontation by police at gunpoint, followed by a rapid ingestion of some drugs. We don't know exactly how many, but there was an admission that he had done it at the time of the stop. That is medical evidence. So we don't have the benefit of on-the-scene medical vital signs on May 25th. So the May 6th, 2019 case is relevant only to that extent. Mr. Floyd's emotional behavior, calling out for his mother, all that is not admissible because the emotional behavior in his state of mind is not relevant. The May 6, 2019 evidence is only admissible for the limited purpose of showing what Mr. Floyd's, as an example of Mr. Floyd's bodily reaction, his physical symptoms upon being confronted in almost the exact same situation.
This is all about cause of death. How did George Floyd die? Why did he die? We know what prosecutors are going to say. They're going to say it's Derek Chauvin's actions that ultimately caused his death. That's an element of everything he's been charged with that they must prove. But now we know what the defense will and can argue. They're going to talk about the drugs. And my guess is when their expert comes into the courtroom, will say, yeah, it's a very reasonable explanation for what happened to George Floyd is that the drugs caused his death. And now with this 2019 arrest coming in front of this jury, you know, part of it, it's a much stronger argument for the defense. Absolutely is. Will the jury believe it? No idea. But going into the trial now, they have a little bit more evidence they can put in front of the jury and an argument that is based on more than just an expert testimony. Now they've got a video of what happened in 2019. Let's bring in Court TV legal correspondent Julia Janae, who is live in Minneapolis tonight. This is big, Julia, I think, and a major victory for the defense. It's not everything that they wanted, but it's much more than they had before today.
Huge win for the defense, and I think it's enough to accomplish what they likely want. Yes, they are making the argument that this goes to cause of death this time. The other times that they tried to argue unsuccessfully to get in this video, they argued different things about this being the pattern of George Floyd, this being his MO. So now they're getting it in under cause of death. But the big thing that they really want, we understand attorney strategy. They want this jury to see George Floyd in handcuffs to show that he had this prior criminal history, that he had this history of using drugs and swallowing them when he was around officers, to try and get jurors to that conclusion that he did that May 2020. So that's what the win is. Yes, they're not going to get in that full video, but I think even that portion that we've identified is going to be shown. That's going to be enough to accomplish what they were hoping all along.
All right, so let's do that right now. And again, this is what we believe will be the portion of the video that the jury will now be permitted to see. So let's take a look at it, and then we'll talk about it on the other side.
Okay, relax. Just undo your seatbelt. Let her take care of her guy. Just keep your hands out where I can see him. Hey! Let me... Keep your hands where I can see him. Okay? Put him up on the dash. Put him on the dash. I'm not going to shoot you. Put your hands on the dash. Put your hands on the dash. The last time I'm going to tell you that. It's simple. He keeps moving his hands around. He won't listen to what I have to say.
Put your hands on
Okay.
top of your head.
What y'all doing on your head?
Top of your head.
Okay, man.
Open your mouth. Spit out what you got. Spit out what you got. I'm gonna tase you. Spit it out. He's eating all
Don't you
kinds of
jerk
stuff.
away from me.
That was one yellow pill.
Put your hands behind your
That was one yellow pill, boss.
Okay, now slowly come on out.
Damn, man.
Hand on your head. Put your hand on your head. Okay, relax then. You're not going to get beat up or nothing if you just follow what we're asking you to do.
Julia, there's a couple of things. When you watch that video, a couple of things I think strike me. One is that the tone of voice of the officer is very similar, and the concerns of the officer very similar about the hands, and the drawing of the weapon, also similar.
Very reminiscent of Thomas Lane when he approached George Floyd May 25th of 2020, where as soon as he doesn't see George Floyd's hands, he draws his sidearm in the same way, even using curse words to get him to comply, and then finally putting it away when he is able to see his hands. It is a different arrest. George Floyd seemed to show his hands to Thomas Lane a lot sooner than he did with these officers on both sides of the car. But again, the defense just wanting to make sure this jury sees him not complying, the officer saying you didn't follow what I'm trying to tell you to do, and spit it out, meaning the drugs are in his mouth, which is what the defense is going to be arguing happened on May 25th.
And when you talk about the tone, a lot of people have commented about the tone of Lane when he first approached George Floyd, but it's similar in 2019. I've had some guests, police guests on the show who have criticized that. I've had others who've talked about, well, that's the tone that you need, that you're trained to use to get compliance in a situation where you are not getting compliance. So again, it's a mixed bag, and I think we're going to hear the same sort of mixed bag in terms of expert testimony at trial talking about this confrontation with George Floyd, with what police are trained to do, what they're supposed to do, because I'll tell you what, I've heard different perspectives from different officers, which to me is fascinating, that it's not cut and dry exactly what we're seeing and what we should be seeing in a situation like that.
It can be jarring to watch it, and there's a lot of energy that's coming off of the screen when you're watching that body camera video. These jurors haven't necessarily seen the body camera video. A lot of them reported they've only seen the bystander clip. So this will be their first time watching an arrest. If they are not familiar with use of force practices or watch a lot of TV that involves this, then this can be very jarring for them to watch. But there will be use of force experts on both sides who will be saying different things about what is proper and what is not. I've been trying to figure out how the state may be able to use this to their advantage. It doesn't seem like this is in any way a positive for them to have this 2019 video in, but it may be a way for them to show the difference in procedure in how these officers in 2019 handled the arrest, which didn't end in a death, didn't end with George Floyd on his stomach with a knee on his neck, compared to May 25th. If it's so similar, then it seems the approach to the person was dissimilar.
Yeah, I think, and I'm wondering if they can even go down there if they want to open up that door, because if they do, where we've seen the difference is that in 2019, George Floyd, when he's put into the cruiser, goes in. But in 2020, when they try to get him in, he doesn't go in. And that's where everything is much, much different in 2019 and 2020. But how about George Floyd's emotional behavior? And the judge specifically ruled about that today as well. And I think that's an important part of everything that was ruled upon today.
He did. He mentioned it when he was talking about the May of 2019 video, when he explained why he was cutting it off at that moment of handcuffing rather than allowing the entire video, which we know goes on to you hear a lot from George Floyd as far as his emotional response to this arrest, where he is really crying and sounding very disturbed. He's talking about his mom, saying he's worried about being shot. That goes to an emotional state that the state expert, Sarah Vinson, was going to testify about to explain in May of 2020, the incident that we're here about, that his response would have been consistent with paranoia, panic, anxiety, claustrophobia. But today, the judge ruled that she cannot testify about that. It doesn't go to cause of death. And he really explained that it's neither the state nor the defense that can get into George Floyd's state of mind. Take a listen.
Well, there are certain things that are not relevant. Mr. Floyd's emotional behavior is not relevant to cause of death once he is pulled out of the squad car. His statements, while they are very similar to what was said on May 25th, don't really establish anything other than perhaps his mental state. And as I think the state correctly notes in its memo from yesterday on page 3, Mr. Floyd's internal motivations on May 25th are immaterial. Whether he was genuinely anxious, claustrophobic, or suffering a panic attack, or whether he was malingering, is of no consequence. He was exhibiting certain behaviors which are evident on both videotapes, both May 6th, 2019 and May 25th, 2020. But they were the behaviors, regardless of their source, regardless of their motivation, whether they were due to anxiety or due to malingering, doesn't matter, because it is the behavior that the officers in both cases were required to deal with. The behavior is remarkably similar in reviewing the tapes. However, that does not make the emotional behavior of Mr. Floyd admissible.
Vinny, the judge there making this King Solomon type decision. The state can't get in their forensic psychiatrist testimony, but also the defense can't get in that full length of the body camera footage showing the emotional response of George Floyd back in 2019.
Yeah, I think this is a very precise ruling by the judge, and one where, as a judge, right before a trial, you're making these rulings on what's admissible, what's not admissible. If there's things the defense wants to get in, the judge has to really consider it, because that can always become a basis to overturn a conviction if and when it happens, right? If the prosecution is trying to get something in and they don't get it in and they lose, they don't get to appeal it. So it's not as, it doesn't have as much potential damage afterwards, right? Only beforehand. So when he's making these decisions, you've got to make sure you're not impinging on any rights that the defendant might have. At the same time, the judge is very cognizant of not trying to put the victim in the case on trial. And I think today he was able to kind of balance that and walk that fine line and allow something in to allow the defendant to defend himself, but at the same time not allow the defense to put George Floyd on trial. So really a fine line, but it looks like he has been able to strike that balance with the way this decision came down today.
It is a fine line. It does cut on both sides, but I still think the defense, with their overarching goal of getting in that May 2019 video, I think they are the ones who come out much further ahead on that ruling, just because it's not really, in my opinion, about getting in the entire thing. They just want to make sure this jury knows about his criminal history, and they'll know that just via this video.